I'm chair of the Philadelphia chapter, as well as an independent game developer here in Philadelphia, as well as an adjunct professor here at Drexel University. If you are not familiar with the International Game Developers Association, IGDA, it is a national organization that advocates for issues surrounding game development and game developers and folks who have or would like a career in game development all around the world. There are various different chapters in major cities around the globe, although it is a nationally based organization. Different chapters serve the needs of their communities in different ways, depending on what those needs are. Here in Philadelphia, we support our very vibrant, professional, academic, indie, and hobbyist community here. It's a very large, very vibrant community, and happy to serve as the IGDA chair and help all of you out with doing monthly meetings such as this one, where we meet every second Tuesday, usually here at Drexel University, with a speaker or multiple speakers in this case, to share their expertise and knowledge with all of you and give you all an opportunity to be able to network and meet other developers in the area. If you would like to learn more about the IGDA as an organization as a whole and would consider becoming a member, you can find that information at www.igda.org. Do consider joining as a dues paying member. There are a number of wonderful benefits that you get as a member of the IGDA, including access to the official IGDA Discord, which gets you a great networking opportunity for over 1,500 game developers around the planet. Really wonderful, wonderful deal. Can't highlight that one enough. If you would like to learn more about us as an organization, you can go to philly.igda.org. You can also join our Discord by emailing us, and we'll send you an invite link at our email address, which is igdaphilly@gmail.com. Join our Discord. That is free for everybody, regardless of if you are a member of the IGDA or not. So same as all of the events that we hold, such as this one. We'd love to see you join that channel and learn more about all the cool things that we're doing in Philadelphia, as well as the things that we do with our sister organization, Philadelphia Game Mechanics, who are also co-hosting this event with us tonight. So we do a lot of cool things with that organization, so you can learn more about that at our website. You can learn more about Philly Game Mechanics at phillygamemechanics.com. One last thing really quickly, we do have a code of conduct, so please check that out at that same website I gave you, philly.igda.org, where you can read it in full. Just in general, be sure to respect each other, respect the space in all of your communication, whether you are here in person, networking and chatting with your fellow game developers, checking out all the cool things that they're working on, or if you're talking and chatting in the digital space over on our Discord. We try to be safe and inclusive to everybody. So we hope that you will respect that. So yeah, you can read those details for the code of conduct in full at philly.igda.org. All right. So with that, tonight, I'm really excited because we're talking about an area of game development that not a lot of people think about, even though it's probably one of the most important things that game developers do need to be thinking about. These are different areas of business development, which typically means the money side and the legal side. So what we've done today is we've put together a wonderful panel of legal experts and accountants to be able to talk about the things that you need to be thinking about when you have an organization or are starting an organization, and from all different angles, because there's a lot of things that people don't tend to think about, and they end up falling into a lot of traps that could be avoided if you just talk to a lawyer or if you just got an accountant. So that's what we're going to be talking about tonight with our panel. We also have a couple of members from the Film Incentives Group to talk a little bit about an opportunity here in Philadelphia and Pennsylvania that you might not know exists as a pre-existing business. That's the Pennsylvania tax credit, which could be changing in ways that not a lot of us are very excited about. So I'm going to let the panel talk about that in just a second. So we're going to get into all of that and more tonight, but really quick, let's first introduce our panelists. So panelists one by one, starting closest to me. If we could just do a quick introduction to everybody, including our wonderful panelists online as well.
That's me.
Yes.
My name is Dave Bowers, and I was a certified public accountant, but that was a long time ago. I just happened to, by accident, get into the film and television business by owning some production facilities back in the 90s and and producing television shows. And we're going to lead towards tax credits, but one of the things that happened was Pennsylvania joined some of the other states that offer tax credits, incentives for film and television production. So there's a lot of money available for that. HBO is shooting the second season of Task, and they're getting $49 million. But there is a separate tax credit for video game producers and production. We're going to get more into that a little bit later. Tom is my partner in a lot of this. So the panel here is going to show you how to become multi-millionaires, and those guys are going to do it. So
that's not true, for the record. Disclaimer, that's not true.
First legal disclaimer.
Yeah, exactly. There's another one coming.
Okay.
My name's Tom Hill, and I spent most of my career in corporate accounting. And the way I got involved in the film tax credit and video tax credit business is one of the last companies I worked for was a company called Shooters in Philadelphia. It's now called Alchemy. And they did a lot of stuff, a lot of TV shows, for example, Restaurant Impossible and things like that, which as soon as the tax credit became available in Pennsylvania, we started taking advantage of that, started working with Dave. I've since retired, and now I work with him, and I get involved at the tail end of the tax credits when you got to get an audit done by a CPA firm and submit a bunch of reports to the state. My biggest accomplishment in video games was I had the high score on a Qbert machine in the mall in Dalton, Georgia in 1983. So nobody probably knows what Qbert was, but it was a neat game way back when.
You were in my game history class.
Oh, there you go. So there you go. So that's it.
Thanks. Hi, everyone. I'm Zach Lewis. I'm an attorney licensed in Pennsylvania and California. I work at a firm called Frankfurt Kernet, and I am in our video game group and our AI group. So I work with clients ranging from indie developers to AAA publishers on all matters that come across during the life cycle of a game. I mostly focus on like tech transactions and intellectual property issues and advertising issues. But we work on everything from corporate formation to financing to monetization strategies, just general legal risk mitigation. I've worked on the policies on how to use generative AI or not use generative AI for most of your favorite video game companies, which I'm very lucky to say. And yeah, I'm just excited to be part of this organization. I haven't been here before, but want to get more involved.
Hello, everybody. My name is Evan Blackman. I am an enrolled agent, the IRS. Essentially, that means I am a tax advisor. I run a small firm in Philadelphia where we work with businesses and their owners to do tax planning, file their taxes, compliance, and manage their tax liability. That could look like doing estimates so that you're on top of your payments to avoid penalties, including some retirement planning to make sure you're getting all the benefits you can on the tax side while reaching your goals in life.
Say it.
Hi, everyone. My name is Saida. I am also an attorney. I am based and licensed in California. I run my own practice here. I have been practicing technology mergers and acquisitions for over 8 years now. Before starting my practice, I used to work for big law firms that represented some of the largest gaming companies, DLA Piper and Fenwick and West. And I did a number of tech M&A deals related to gaming for companies like Niantic. So now in my own practice, I work with smaller private companies and game developers, studios, and owners like yourself. My goal is to make sure when you have that life-changing deal ahead of you, I am doing my best to protect you because I know what's coming down the pipeline, right? So I have a similar practice to the other attorney on the table here, and I think you're going to hear us say very similar things from time to time, but typically I show up when there is a large transaction. You are either taking funding from a university sponsor or a studio, or you are entering into a term sheet to sell your intellectual property, your game, or some aspect of it. So that's me.
So real quick on the note before we get started, I should disclaim I am an attorney. I'm not your attorney. Nothing I say is legal advice, but if you need some of that, you can talk to me afterwards.
I knew I was going to hear it at some point.
Exactly. Since it's going online, I might as well put that out there.
Awesome. Thank you. No, really appreciate it. Really good group here with a lot of shared knowledge. Can't wait to hear from all of you. I do want to get started talking about the tax credit incentive and talk a little bit about what that is and who should be thinking about it and how they can apply and all of that. So Dave and Tom, I'm going to let you take it from there. And should I get started with
Yes,
the
please.
pamphlets as well as you chat?
We put together this really fancy handout. So Pennsylvania, like a handful of other states, has incentives available for video game production. The incentives, they're not grants where they just give you money. They're not rebates, they're tax credits. That's how the state incentivizes big companies doing all kinds of economic development to the smaller companies like us. So you may say, well, what do I need a tax credit for? Because I don't have any income. However, these can be sold. That's the whole idea behind them. And we do sell them. So we'll help you. We'll basically offload everything from you. If you've got an idea for a video game or that kind of intellectual property, and you have some funding and you're going to be spending money on it, you're going to have a partner in this, and that can be the state of Pennsylvania. Other states have this too. New Jersey does. New York certainly does. And we'll go through the whole process. You do your thing, we'll do ours. Do the application, the accounting for it, get the credit, and sell it for you. So whatever you spend, you're going to get in Pennsylvania, you're going to get a credit equal to 25% of that, which then can be sold and net you about 90 cents on the dollar. So I did put together some of the stuff that's there. I'll let Tom talk about some of the details of all of that. But I also want to say there's another credit available, a federal and a state research and development tax credit. And video game production meets the criteria for that too. I don't want to get into that in a lot of detail, but all of this stuff is free money to some extent. And you can get both credits on the same spend. So you could get up to 45%, let's just call it a rebate or tax credit on what you spend on this. So we'll take care of all those little things. Feel free to email us or whatever. Tom, why don't you talk about some of the details of like what's eligible and the process?
So the way it works is, let's say you're putting together a group and you're going to spend some money on a video game, and you apply to the state of Pennsylvania, and what they do is you'll say you have a budget of $100,000, and that would be a small budget, but let's say you got a budget of $100,000, and you're going to spend all of that in Pennsylvania. So you're going to pay yourself something, you're going to hire some subcontractors, you're going to buy insurance, you're going to buy equipment, you're going to rent equipment, you're going to rent a facility. All of those expenses, if they're done in the state of Pennsylvania, are eligible for this tax credit. So, and you have to, it doesn't all have to be in Pennsylvania, but 60% of the expenses have to be in Pennsylvania, or you don't get any credit at all. So you're spending the money, you're paying yourselves, you're paying employees, you're paying subcontractors. And then when it's, you're going to, first of all, get Dave or to submit an application to the state, explaining what you're going to do, how it's going to be funded, how much you're going to spend, and if hopefully you will get approved for that tax credit. So then what you do is you go and you do the work. And when you're all done, you go back and you say, okay, I'm finished. And then you got to get an audit done. So that's when I come into play. I'll work with you to gather all your expenses. I'll work with a CPA firm. They'll audit it and you'll determine, yep, you spent $100,000. It was all in Pennsylvania. And the tax credit, by the way, would be 25% of that. So you would get $25,000 on 100 as a tax credit. So when all's said and done, you submit the audit to the state. You have to do an economic impact report because they want to know, was my money well spent for the tax credit? And if so, you get the tax credit certificate, and then we get a broker to sell it to somebody who has liability for taxes in Pennsylvania. And their benefit is you're going to say, I got a $25,000 tax credit. I'll sell it to you for 22,000. Then they made 3,000 on the deal and the money will change hands. So it really is a good program. You'll either, if you have a company yourself, or you may end up working for a company that applies for the tax credit, but it is a way to help incentivize people to do video game production in the state of Pennsylvania. Just like the film tax credit encourages people to come and shoot films or television shows or that kind of thing in Pennsylvania. So it's just something to be aware of, because if you are to do something and develop a game and you spent money doing it and didn't at least see if you could benefit for the tax credit, you're giving money away that you could potentially get for doing the work in Pennsylvania. Did I cover everything?
Perfect.
Now, do you want to talk about how the tax credit came in? The video game tax credit was an extension of the film tax credit, or,
Yeah, kind of.
and then they're
It's-
threatening to take it away.
We also often talk about the film tax credit, and a lot of that money is going to companies, HBO or Netflix is coming into Pennsylvania, spending a lot of money, getting a credit, and taking a lot of that money, or a lot of those workers back are from New York, California. But this credit is pretty pure in that, it's helping Pennsylvania residents. And probably a lot of people live, the money you make off of producing this and get paid wages, salary, whatever, you're going to spend in Pennsylvania. So that's the idea behind this, is to encourage graduates from Carnegie Mellon, certainly Drexel, to stay here in Pennsylvania as opposed to going elsewhere. So we certainly lobby the state to try to increase the amount of this credit. It is, and somebody's going to talk about, it's kind of in danger right now, but we'd like to have it expanded so we can have more money going to the producers and grow the industry here in Pennsylvania.
Awesome. Thank you so much for the information. And yeah, absolutely. I think that's like the number one thing is like, we would like the tax credit to continue in its current form, maybe even possibly expanding it, because that really just helps developers and helps grow and keep things in Philadelphia. We know a number of you are students here from Drexel University. We'd love for you to build new studios and have those studios grow. And this tax credit only helps that. We talked a little bit about like what the current status is and what's happening with it right now.
Yeah, there's $1 million available, and that's not a lot when it comes to the state. So
100 million for the film tax credit.
So we do some lobbying. There's only so much we can do, but it really helps when Pennsylvania residents and taxpayers contact somebody, whether you're local state rep, state senator, and let them know how important that is to you. You may not think it's important now, but it will be. Or all the jobs will just go somewhere else. So, I think you've done some more lobbying, and I think Nick has somewhere too. So, so if any of you know any of the politicians, now's the time.
And
if you don't, we can put you in touch with them.
For sure, yeah, and some of us, including Nick from PHL Collective, as well as myself on the IGDA, are working with Councilman Isaiah Thomas as part of a gaming task force to increase the tax, help increase the tax credit, at least on the Philadelphia side, and get Philadelphia involved in that conversation. So, absolutely, awesome. Well, thank you so much for the information. Really appreciate that. And as we kind of move into Q&A, if folks have specific questions about the tax credit, that can be included in the questions. But at this point, I would like to open it up to the rest of the panel as well to ask questions related to the legal and money side of games. For my folks online, if you have a question that you would like to ask, there is a webinar option on Zoom. Just at the bottom, you'll see a Q&A button, and you can start queuing up questions that are going to appear on my computer that I can ask, as well as the questions that are being asked online. We'll go back and forth so that we can try and get through as many questions as we can tonight. To get us started, I just have a quick question for the entire panel. I'm kind of curious to hear from everybody. If let's say you have a new client or someone who is brand new to this, what's like the most common mistake or the most common assumption you see that they come in with, that like if you could tell this person like one thing that they should know, or like what's the most common pitfall that a person falls into and how they could avoid it, what would that be? And we can start. I'll start with Saida.
Yeah. If you're very new to gaming and you want to make money off of it, I would say the most important mistake folks made is not understanding where the ownership of the intellectual property that you are developing lies. Literally, the number one killer for investors, deals going in, and it works on both sides. So the basic rule of thumb under federal law, and this varies state to state, but the basic rule of thumb is if you have a studio or a gaming company, then any work done by the employee, if you are on W-2, belongs to the company, if you are doing it on company time using company resources. And the rule of thumb is if you're not a W-2, and this is where a lot of mistakes are made when you first start off, you have a bunch of friends getting together, building your games, or you hire a freelancer to do like a voiceover for your gaming product or like be the voice behind a character. For contractors, the intellectual property belongs to the contractor. Even if you have paid the contractor in full all the money, the default is the intellectual property belongs to them until there is a very specific written agreement assigning that intellectual property to the owner or the person paying for that service. So this general concept basically cascades as a domino effect, and it snowballs into huge problems when it comes to like an M&A and it lands on my desk. So if you are just starting off, you're very new to this, my number one tip would be understand the role that you are playing. Are you the developer? Are you the contractor? Are you the employee? Are you the owner that's hiring someone? Understand your legal role. And the second thing is make sure you understand where the intellectual property is. And if it's not at the right place, reach out to me or the other attorney here or anyone else that you know, and make sure your intellectual property is properly assigned to you if it's supposed to belong to you, right? And it has to happen at day zero. Because once you get an investor or a term sheet on the table, the entire deal can fall through because you can't call up the contractor you hired offshore from 6 years ago or even find him, right, to get a retroactive intellectual property assignment. Because literally that's the only remedy at that time available to us. And oftentimes they'll hold you over the barrel because they know you're hostage to their consent and they'll ask for a lot of money, or the buyer will just drop their price. All kinds of bad things will happen. So my number one tip is understand who the intellectual property belongs to and who you are in that decision-making tree.
I would say probably opening a business account or a business card and creating that division between your personal expenses and your business expenses. That can be very beneficial because I've seen lots of people come into my office and I meet them and they're having to go through their personal bank statements and highlight everything they thought they spent on their business. And it can be a huge pain to clean up. And having that separation is good legally, but I'll let the lawyers talk about that. But it can be very expensive too. If you own the studio and you have other things to do and you need to pay an accountant or bookkeeper to sort out that mess, it can become very costly when all you needed to do was get those accounts set up and have discipline where you charge your expenses. And come tax time, everything is, in one account where you need it. You know what your inflow and outflows are, and it might seem really simple, but it really can. Not doing that is a huge headache.
My co-panelists had really great points about making sure that your IP is owned and protected. And adjacent to that, I would just say in general, one of the big mistakes that I see is people underestimating the importance of a contract and not having actual written deals for the transactions they're engaging in. So you might be working with a small group of people to develop a game, and maybe there's like this understanding, so to speak, that you're going to be the owner of the game and they're going to get paid this amount, but nothing's on paper. It's just a handshake deal. Everyone is friendly when things are going fine. It is when things go badly or things go so well that you make so much money that people start to try to change or like pull back on what was initially agreed to. Well, actually, I did more work than we thought, so maybe I should get like a 25% equity in your entire company instead. Um, I, I think that people want to be trusting of the people that they're working with, and I think people don't want to spend a lot of money on lawyers, but it is a small investment up front to protect yourself from what could be, it could cost you your entire game and a lot of other money down the road. Let's say that you hire somebody to work on something for your game and they actually stole whatever they give you from somebody else. Your game's a massive success, and now a third party sues all of you, right? You should have an agreement that says that the person who gave you the stolen stuff is responsible. But if you don't, you're all just going to be on the hook for the most part. I could think of like a bunch of other scenarios that are sort of like that, but in general, if you aren't having an agreement with a person that you are exchanging money with, you're taking on a lot of unnecessary legal risk.
Dave, I don't know if you wanted to weigh in on this, if you had anything.
No, just that I agree 100% with everyone's saying. I mean, I'm sure if you guys are in the game development, you're brilliant from a creative standpoint, but you got to spend a little bit of time up front getting your business stuff in order. And that's the same from a legal standpoint or an accounting standpoint, because if you don't, you can be in a whole lot of trouble later on. I mean, if you watch that movie about Facebook and Zuckerberg and all that stuff.
That's exactly, yeah, exactly.
You just, even if you're starting small, it doesn't take much. It doesn't cost a whole lot. You just need to make sure you got things going right from the beginning to avoid problems later. I mean, get somebody who has a little bit of accounting bookkeeping background to help you set up the books and, talk to an attorney and that sort of thing. So that's just, a recommendation from a whole career in business and corporate accounting is if you don't get that stuff straight in the beginning, you're going to get burnt later.
Poor Tom here, when he puts some of this work together, the producers are out there, they're hiring people or they're paying people in the field or whatever. And nowadays, sometimes I paid him $1,000 over Venmo. And it's like, oh, well, that was really nice. Like, but what was it for? Like, well, we did something, tried it.
Did you send them a 1099?
Get this stuff written down as to what it is. It'll haunt you later on. Also, some simplistic things that I see is if you have an idea and you have your little LLC or whatever, and somebody's going to pay you to produce something, this comes back to the intellectual property. Make sure if you know very specifically, is it a work for hire and they're going to own it, right? It's just those words. Is it a work for hire or are you going to own some of this? And, because it's going to affect everything after that. So make sure you have an attorney to help. A lot of times it starts out as a term sheet, just one page, and make sure all that's very clear because the company you're going to be working for, if it's you producing the whole thing, you're giving away your intellectual property, they'll definitely take it. right? And they'll exploit it.
And there's actually a little bit of gray area there too, where there's at least like some wiggle room when you're having these kinds of negotiations, right? Like if you are being engaged by someone to do work for hire, meaning everything you do is going to be owned by them, you could then, as part of the same deal, request a license back. So basically, I'm making something, you own it, you give me the right to put it on my website so I can show the world that I've worked on this product, or I'm allowed to, like go to a conference and like play this video, this trailer that I worked on at something. Like whatever it happens to be. I want to be able to make t-shirts. You can make the game. I just really want to be able to sell t-shirts with the character that I come up with. Whatever it happens to be. It doesn't always have to be so black and white, like someone owns everything and has all the rights and the other person has absolutely nothing except a paycheck. There really is like an infinite number of possibilities for how a certain deal could go. So that's always something to think about as well.
We have a great question online. Oh, couple coming in now. Question from Brandon online. What is the typical lawyer-client relationship? More specifically, does the company pay monthly costs for a lawyer to be the business's counsel? Are lawyer services more a la carte, or is there a combination?
Yeah, I can take this one. So I would say you have all the flavors available to you. That's where I'm going to start. You can find lawyers who'll agree to whatever arrangement you need at your price point. And I advise you work with the right lawyer at the right time in your business, right? And not all lawyers will fit your size. Typically, and I will let other people chime in as well, but typically what I do is I work a la carte depending on what you need. So sometimes just a developer will come to me and say, hey, a studio wants to hire me to build XYZ character. Here's an agreement. Can you just look it over half an hour and make sure I'm not getting screwed over? And this is what I care about the most. This happens a lot. Sometimes I'll have an entire studio come and say, hey, we have a big offer to be bought for $15 million by, Electronic Arts, right? These are the terms they're laying down to me. I have no idea how to get started. And then we enter into a retainer agreement because I know this is going to be a long 2 to 6 month process trying to sell the entire game or a complex product. So it really depends on what you need, and all of these options are available. I will say in Silicon Valley, the practice has become very standardized for startups because we know startups don't have a lot of money. So, how do you set up your game business? Like what kind of IP protections you get? All of this is kind of standard market. So if you work with an attorney who knows what they're doing in the space, they'll just be able to do it for you for what I would say is a reasonable market fixed cost, right? And feel free to add what you will, but generally the professional lawyer-client relationship is that if you have a business already or a group of founders, the business will hire the lawyer and the lawyer is loyal to the business and they advise the board. And the officers reach out to her, like the CEO, CTO, they reach out to that person for advice from time to time. You can have individual engagements. Like I said, if you are an individual game developer and you need representation for yourself against a company, you can also hire a lawyer for that. Once a lawyer becomes the company's lawyer, there's a conflict of interest against being your personal lawyer. So like in an M&A type situation, a lot of the times, depending on the type of deal terms I'm looking at, sometimes I'll tell the lawyers, the founders, to go get their own individual lawyers if I'm representing the company. Because sometimes in a transaction, not all of the terms are aligned in interest. And it's up to the lawyer to tell you, it's their professional responsibility to tell you when they see a potential conflict of interest arising and advise you to get your separate counsel. And you should always ask your lawyer if that comes up. Sorry. Yeah.
No, that's all really great points. All absolutely correct. I will say in general, the relationship is you're paying by the hour, at least for now. I do think generative AI is going to change a lot of that. But typically there are some things where like you might get a flat fee for like forming my LLC or doing a trademark search or drafting a 1-page NDA agreement, whatever it happens to be. Those could be like fixed fees. Otherwise, I might have someone come to me and say, here's my online social casino. Can you tell me what the gambling laws are in all 50 states and write me a memo about whether my game is going to be legal in all of them? It's like, okay, it's really hard for me to estimate what that's going to cost. I could give you an estimate, but ultimately it's, and I can let you know when it's approaching that, right? But like, depending on what you're specifically asking for, the cost can vary. But that said, you should have a relationship with your attorney where you're actually comfortable explaining to this person that you're working with what your goals are, what your concerns are. Like you shouldn't be leaving a call with an attorney feeling like, they took too much control of everything and you don't really agree with the way that things are going. At the end of the day, they are the means to your end. Like you should be getting what you want out of them and you should be using them as like a resource. Even a little bit of like business advice, or maybe even sometimes I play like therapist every now and then and tell people it's going to be okay. So I would say, financially, for the most part, it's going to be paying by the hour. On like a more human level, I would say you want your relationship with a lawyer to be good enough that you could sit down to have dinner with them and you wouldn't hate it.
Rob would like to extend this question to the rest of the panel for your specific occupation. How are you commonly engaged and hired with new clients?
Yeah, I will answer from my perspective. So, as a tax accountant and tax advisor, and I do some bookkeeping as well. There's a couple ways that you would generally work with a tax guy, and the most simplest time is like a once a year engagement. You show up, you hand me all your information, I file your taxes. It's usually a fixed fee. Some tax professionals will charge hourly, but that's pretty straightforward. If you're have a more complex business and you have quite a bit going on, especially when you're starting to turn a profit and you have to monitor what your tax liability is going to be, it tends to be over the course of a year. I mean, and I call this tax planning instead of like tax filing. And you'll usually meet multiple times a year, sometimes once a month, to make sure that the money that you're bringing in is covering your taxes and you're setting that aside and you can make sure you're tackling all your deductions. You can ask me or whoever your professional is, can this be deducted? How is it supposed to be deducted? Because there's so many ifs, buts, and exceptions. And so that's on the tax side. It's either going to be a once a year or some sort of ongoing engagement. I charge that like a monthly subscription. Some tax professionals will charge it hourly. And then the other half of my business, which is bookkeeping, which is like doing the day-to-day accounting and preparing your financials to review, that's certainly going to be charged on a monthly fixed fee.
Tom and I work for free. So that is until we find money for you and you're about to get it, then we take a percentage of that before you get your share. So it's usually 10%, 15%, depends on what it is. So feel free to call us or email us. It won't cost you anything.
Yeah,
It isn't quite free.
a lot of people, I mean, I don't deal with the initial meetings with clients. Do they reach out to you? Do you look for them? I mean, how do you find,
A lot of we've been doing this for so long. It's word of mouth, or they have a question. Don't be afraid to ask any kind of question. If it gets into an area that's not our expertise, we'll probably refer you to one of these guys. We get those questions all the time. I need an attorney. I'm working with talent and I need a talent agreement with them. How do I deal with my staff? Make sure you do. I mean, this sounds dumb, but if you have employees or are an employee, make sure there's some kind of rules somewhere so you're not going to get charged with harassing them or something. Like I said, especially when somebody finds out that you've got $1 million or $10 million idea, then everybody thinks that they came up with the idea.
I do have another question online, but I want to make sure we get some people from the room too. Yes.
Sorry, I was going to ask you so that I also I do have a question.
Yeah, please.
This is slightly off topic, but because we've been talking about IPs all the time, can you just define the scope of an IP? Like, is it the assets, really what you can use? Like,
So I'm an intellectual property lawyer, so I'm happy to cover this. And my co-panelist is, I would love to her to chime in afterwards. Intellectual property, it really falls into three buckets and a side fourth bucket that I'm going to talk about. There's copyright, which is what protects original works of authorship. And that's an important word because the Copyright Office says that AI is not an author because an author has to be human. Copyright protects original works of authorship fixed in a tangible medium of expression. What that really means is things that you're able to perceive that have been created by someone else's mind. So think of songs, books, films, TV, video games, code, anything that was created by a human being. And again, it's fixed. So if you hum a song out loud, you don't own the copyright in it. But if you were to record it, or if you were to write it in sheet music, you would own the copyright in either that sound recording or the composition. Then you have trademarks, which are what protect source identifiers. So this is like trademarks are images or logos or slogans that help consumers understand where something is coming from, like the McDonald's Golden Arches or Just Do It by Nike. And then you have patents, which are inventions, and you have to be specifically licensed to be a patent attorney, which I am not, nor do I ever want to be. But if you need one, I can find one for you. And then you have the right of publicity, which is someone's name, image, voice, or likeness. That's technically their intellectual property. So if you were to make a video game and you want to put, you know, a version of your favorite politician in there or your favorite celebrity in there, they actually own the right to their own likeness and they can come after you for that. So typically, IP covers like the things you create unless it was already owned by somebody else.
Did you have anything to add to that?
Do you want to repeat the question for the online folks? I think someone said they couldn't hear the original question.
Yeah, we got that. No, I was gonna make sure to make that a priority going forward. Absolutely.
Oh, sorry. Yeah, the question was like, can you define the scope of what is intellectual property? Since we're talking about what is intellectual property and protecting your intellectual property, it's everything that you're working on, that you're creating, that you're authoring from your mind, with your actual human hands, not with generative AI. Is now the time for my tangent on generative AI? Or I'll save it for later.
Yeah, Zachary, definitely jump into generative AI. I want to add, in terms of intellectual property, we also give value and count trade secrets. So
Yes.
It doesn't fall into copyright, trademark, and patents, like Zachary said, but trade secret, the most famous example is the Coca-Cola formula, right? It's not something that you can copyright. It's not something that you can trademark. It's not something that you can patent. You can't really put your fingers on it, but that's what generates value and revenue for your business.
Yeah. The other example I like is the secret herbs, the blends and spices from KFC. Technically a trade secret.
Okay. Yeah, Coca-Cola and KFC. The best thing to do with trade secrets is to keep it secret. There's too many ways in which people don't do that. If you go around sharing with your friends, you can lose trade secret because you're not treating it like a secret. So the best thing to do is to keep valuable information secret. Do not develop games on university-owned property. If you are a PhD student and you work for a university and you don't want the university to own all of your IP, do not use their resources, like their laptop or their lab. There's actually many famous lawsuits that came out of this very same fact pattern, right? So make sure you're not using your universities or employers' resources to build any IP that you want to own. Because if you do, the university will say they own part of it. So I just wanted to add the trade secret piece. But yeah.
I will jump it back in and talk about like the intersection between generative AI and ownership of intellectual property, because I think this is really important for, developers. The amount of generative AI that you use and the way that you use it will heavily determine whether or not you can actually own your intellectual property. And what does it mean to own intellectual property? It means you have the right to exclude somebody else from using it. So if you're going to make if you're going to make a video game and you're going to use generative AI, it doesn't really matter if you use generative AI to make like a forest, because no one's really like, okay, take the forest. But if you use it to make your main character or like the vehicle that's going to be on the cover of the box art, and it was made by generative AI, you don't own that. Anyone in the world could look at it, decide to make a movie out of it, decide to sell merchandise of it, and there's nothing you can do to stop them. Similarly, if you have code, let's say somebody were to develop a video game entirely with generative AI, because the code was written by the AI, it's not owned by a human. And again, you essentially have no rights whatsoever, and anyone can just do anything they want with what you thought was your intellectual property. Which brings me back to the importance of having a contract with somebody, because if you are engaging somebody to do any kind of work, you want to understand or how they plan on using generative AI, or you might want to just outright restrict them from using it. Or, you know, we can get more nuanced and say, if you're going to use it, you have to take the output and modify it substantially and select and arrange and coordinate all the outputs in a way that it's actually your new original creative expression. There are some ways that you can use generative AI and still, you know, maintain some ownership. But in general, like prompt to output, you're not going to own the output. And you have to be aware of that because, you know, if you're doing a deal for somebody and you thought that you owned it because you made it with AI, and they come back to you and they say, can you, you know, I have this deal on the table. Can you help me prove this chain of title for this code? And now you like ruin this deal for somebody because you can't actually give them the right to the asset that you have. The people who wanted to buy it can just be like, oh, we can just use it ourselves. I don't need to pay for anything. You don't own it. So again, like you want to be really mindful about how those things like intersect.
I got a question online that I want to jump into. It's been there for a second. From Cameron. It's also a really good question. I'm a freelancer working for only one client for the last several years for a flat monthly fee. My expenses are fairly small, just a few software licenses. Been working on my own name as an individual. Would I benefit from setting up an LLC and to operate under? Are there significant differences filing taxes, tax rates, any gotchas for being for as an individual doing or going LLC route? As an individual,
you should never be transacting with somebody as an individual, because if at the end of the day, if you're in a lawsuit, they're going to come for your bank account, your home, your car, your everything that you own. That's why we have limited liability companies, because the liability of them is limited, right? So if you are in a transaction with a company, an LLC, and the LLC has wronged you or vice versa, you're only able to get from the LLC what the LLC owns. But if it's just you, me, myself, and I, like doing all these deals with people, and they want to come after me because of that, now I have no liability shield. There's nothing I can point to say, you actually have to go after this entity because technically corporations are legal persons. So you're basically being like, well, you didn't transact with me. You just transacted with my company. Am I the sole owner? Yes. Do I own 100% of it? Yes. Do I control every single thing about it? Yes. As long as you're not commingling your bank accounts and you're separating your business and your personal funds, you're going to be protected in that way. The issue is if you form an LLC and then just start treating it like your separate bank account, you might as well not have formed an LLC.
Yeah. I will also add for this particular fact pattern, Zachary, I think my concern is which state are you in?
Yeah,
because if you are in the state of California working for a single person paying you a fixed monthly salary for more than 6 months, you are considered a de facto W-2. There is a lot of employee misclassification that happens where an employer wants to treat you as a contractor because then they don't have to offer you rights you're entitled to as a W-2, like a 401k, a retirement, tax savings, all of these things, right? They want to treat you as a contractor, but there are laws in some states that protect you. Some states are more protective of employees than others, and California is definitely on the more protective side. So if you are this person in the state of California, I would say you're probably a de facto W-2, and you have legitimate claims for this person who should be offering you a 401k and a bunch of these other things that you're supposed to offer your W-2 employees. So that's just in addition to what Zachary said, and I agree with him 100%.
That's
Not
a
to
great
mention
point.
paying half of the Social Security and Medicare tax.
Yeah, exactly.
Exactly. Yeah, they're probably just passing on all the costs that they were supposed to pay if you were a W-2. So that's illegal. If you are being treated as a contractor by a person and you're essentially an employee, talk to a lawyer, an employment lawyer.
So I want to add on the tax side of things. LLC is not a tax entity, right? So there's a distinction between a legal entity and a tax entity. The IRS doesn't look at an LLC and say, I'm going to tax you as an LLC, right? An LLC can actually be taxed as whatever they really want to, assuming they file the correct forms. But in the context of Cameron, right, who asked the question, As a single individual, you're a sole proprietorship. And in his case, it's actually quite simple. You're going to file your business income and deductions directly on your personal tax return. You're going through like TurboTax or Pre-Tax USA. They usually ask you if you are self-employed, and you would go through that line of questions in the software, enter your income and expenses, and it goes all on your personal tax return. It's really quite straightforward. Knowing that if you're going to get into business, that LLC, you're not being taxed as an LLC, and that's important because as your business grows and it gets more complex, you're going to generally look to change how you're taxed if you're structured under an LLC. And disclaimer, depending on your state, things could vary.
I think we had a question in the back. Yeah. Yeah.
Hey, Tom, you got the, what's the total duration of time it takes to apply for this tax credit?
So the question was, what's the total amount of time that you have to be able to file for the tax credit? I get that right?
Total time it takes
Total time it takes
to apply for it and then receive it.
to apply for the tax credit and then receive it.
Do I have to be specific? Anyhow, you want to apply when you have a project and you have funding for it. Doesn't have to be 100%, but most of the funding for it. Then we would apply for it. Then you have to go and produce it. And then we have to accumulate the cost, have an audit done, submit all that to the state. They'll issue the credit, and then you'd want to sell it. So it's a lot of that's determined by how long it's going to take you to produce the product. But it's not a grant that you're going to get upstream. It's a credit you're going to get when it's all said and done. So, if it's going to take you a year to produce that, from beginning to end, it's going to be at least a year and a half before you see some of that money. Some people will ask, oh, since the state has committed, they're going to eventually give me this credit. Can I borrow against that? Maybe you can find somebody that wants to lend you some money against that, where they're going to buy the credit afterwards. That gets a little bit sticky. So you want to see one of those guys over there.
I'm not doing that.
Well, as Dave said, we're kind of like the injury lawyers you see advertising on TV. We don't get paid till you get paid. And there's been some, and Nick's aware of some of this, that probably a year and a half. It could take 6 months to get it through the audit and then get all the stuff done. I mean, these CPA firms get busy at tax season, so they're not working on the tax credit audits, and you get delayed. And so it could be a long process. A lot, like Dave said, takes a couple months probably to get the application approved. Then it depends how long the video game's worked on. If that's a year, takes a year. And then you go to audit, that could take 2, 3, 4 months. Then you got to submit the economic impact report, and the state comes back and forth asking questions. That could take a couple months. Then you get the tax credit certificate, and then you got to submit that to the state to sell, and they got at least 2 months to do that. So it's a long, drawn-out process, but eventually you'll get
It's
the
worth
money.
it because it's kind of free money.
Yeah, I mean,
We have speaking of the tax credit, another question online regarding it. Is there a minimum budget or funding amount needed to apply for the Pennsylvania game production tax credit?
There isn't, but you're probably going to want at least, I'm going to say about close to $100,000 of spend in Pennsylvania. That's going to generate a $25,000 credit. And, you got to have an audit, and that's going to cost several $1,000s right there in order to make it worthwhile. Then you have to have somebody buy it. They'll want a small discount. So that's a good number. Do we do some for less than that? Yeah. We're trying to help smaller producers get started. And we'll help them out. We'll help them out with our fee and things like that. Yeah.
Thank you. Appreciate it. Do we have a question from the crowd? A couple more online, but I'll jump to the crowd really quickly. Yeah.
You were talking about how if you make something with generative AI, you technically don't own it. Is there some sort of threshold of how much work you have to do, or it's not your thing?
Is there a threshold of work that you need to do on something generated through AI that you need for it to be considered your ownership? Yeah.
No, courts have rejected this idea that ownership is related to to the sweat of the brow, to how much work you actually put into something. That said, there are differences with it's not how much work you do, how much time you spend on it, how difficult it was for you. It's more like, how are you actually using the tools? If you took a photograph and you're using Photoshop generative AI to add like some stuff in the background, or like take the wrinkles off somebody's face to change their age, you're going to own the final product. Again, if you're just on Nano Banana or something and you're like, I need an anime trailer for my video game or whatever it happens to be, you're not going to own that at all. And if you were to do something like, again, like generate like the example is, there's like this comic book, Zarya of the Dawn, where somebody used Midjourney to create the main character for their comic book. They submitted to the Copyright Office, they got approved, then they tweeted, I use AI to make this. It's the first ever AI approved thing. And then the Copyright Office was like, come back here, we're going to fix that. And it turns out that, so this author doesn't own the main character of their own comic book, but they own like the comic book itself. So you can't recreate a comic book that is like the same exact page as theirs, right? But if you wanted to, you could take the main character from it. Technically, you would own like the selection, coordination, and arrangement of the non-protectable assets. Yeah, so arranging non-protected assets can ultimately result in protectable IP, and there is a way to modify generative AI output to so much so that it's your new original creation, but that's very fact specific, and it has nothing to do with like how hard I worked and how much time I put in.
Recently, I've been looking into the AI generated tools. Really small stuff, like line by line, every once in a while there'll be an AI in it. Is that, it would be almost impossible to tell which edits were AI and which ones not. And it would be a tiny percentage. If I mentioned that I did use AI on this, that doesn't suddenly invalidate that I worked on it, right? Like,
not legal advice, but in general, yes, if you're using AI for things like, quality assurance and like finding little bugs, that's going to be classified as using AI as an assistive instrument, not actually generating the code. It would be more so if you were like, give me a script for a, like 2D battle mechanic or whatever happens to be. That was like a lame example I just came up with. But yeah, the answer is you can use it as an assistive instrument. It won't negate your ownership of the code. But if you were ever to submit it to the Copyright Office, you are supposed to disclose how you use AI. If you didn't, could they find out? Maybe if you don't tweet about it, no. But yeah.
Question.
Yeah,
Oh, sorry.
No, sorry. I just wanted to add to Zachary. I think there was a related question in the chat here that I responded to. I don't know about the USPTO office, but if there is a buyer or investor, they will hire code audit firms to audit your IP. So one of the things that you're most commonly asked to produce is a open source or AI generated source code inventory, where you are asked to track and give an assessment of how much you used and where. And they start with your description and they dig. They can go so far as to hire companies like Synopsys that do black duck scans, and now they do AI generative code scans, where they'll use their proprietary software to scan your code, and then they'll also have their engineers look at it. And if there is any kind of question, because really it's not like an exam, right, where you get an A or you fail, right? You're negotiating a deal. So even if there is, so what we're looking for is a buyer's sense of confidence in your work. Is their confidence really high that this is an original work of authorship and the intellectual property belongs to you? Good. Is their source of confidence low based on their audit? Not good, right? So we're talking about kind of like a spectrum, and that's how we deal with it in a particular transaction. So sorry, just wanted to add that.
No, that was great.
In the chat.
So from online from Joe, and this is clarifying some of the earlier topics we talked about. I'm currently in a game development team and developing a game. They're still not sure when we should start considering intellectual properties, opening up a business, and whatnot. Do you all have recommendations when we should start considering the business side? Is it after-
Yesterday.
Yesterday, that's right.
That's what I thought too. I was thinking
Yeah.
it when I was reading it.
Yeah.
Yeah, I can add a little. Yesterday is true because most of the time when people come to us, it's already too late. But I would add there is usually a two-step process gamers can use. This is kind of outdated. I don't know, Zachary, if you see more of it. But at one point, gamers used to use what we called founders agreements. When you incorporate a company, you start incurring franchise taxes and all of these state and district governments, they want you to pay licenses and fees every year. So you start incurring this overhead. So at one point, what gamers used to do is say, we're not going to go formal with an actual company, but we're going to have an agreement just between the three of us or four of us, however many are here doing the coding, is if we ever did have a company, which would have a viable product, then we agree that we would split our future ownership this way, and we agree to contribute all of our IP to this future company. It's called a founders agreement. It was very popular at one point, and then in practice, people realized when you try to go do a founders agreement, you are doing a lot of the heavy lifting for starting a company anyway. So people are like, why don't you just go form the company? But it's really up to you and your vision, right? Like it depends on how long you plan to do it. Like if you plan to do it over the next 3 years part-time, maybe there's a founders agreement is good for you so that there is a clear understanding between all the part-timers about what's happening. But if you're doing this full-time and you're like, I want to launch this, out of my college dorm with my college friends, and this is what I'm going to be doing as my career, then it's probably a good idea to have incorporated yesterday and, made sure all of the bells and whistles are tied out.
Yep.
That's it. Just backdate all the contracts.
Yes, you can. Some of, not all.
Hey, $20 million. What happens in a scenario where a number of people submit that credit and the cap is hit? What happens to them?
Right. So the question is that the tax credit as it stands in Pennsylvania is only $1 million. What happens when that cap is hit?
Well, they have been, let's say there are 10 applications for $100,000 each, that's $1 million. But let's say there's 20 applications for $100,000 each. They have kind of reduced everybody so everybody gets some money. Sometimes they'll check and say, is everybody happy with that? So that everybody's getting some rather than only a handful getting all they asked for. So we need more money.
Is that $1 million a year?
A year.
And the approvals, a lot of these projects, they're unlike what we did with a lot, which are film and television projects where there's a distinct beginning and end. Okay, with a lot of these, they will commit to you over a 5-year period.
Yeah, we didn't mention that.
Develop that, yeah. And sometimes you're going to develop it and just maybe sell the product. Other times you're going to be maintaining it. They're going to commit to you to give you a credit on all of those years. So that's a great thing.
About how many inquiries do you see on a year-to-year basis? Have you kind of experienced
As far as
video games?
oh boy. Well, we're probably talking more about the state of the industry, unfortunately. Maybe I'm seeing maybe 5, 8, 10 tops. But we're not doing all of them. There's others done around the state.
That question was how many queries for the tax credit do we see, in particular in regard to video games currently? Other questions? Yes.
For the IP, is that something you can claim retroactively? You claim retroactively, or you have to register?
Can you claim your IP retroactively?
So your logo specifically, you're talking about a trademark. You have to, depending on where you make it, you may have common law rights in your state to say that you own that logo. Otherwise, if you want to own it federally and exclude other people from using it federally, you have to register with the USPTO, the U.S. Patent and Trademark Office. And in theory, or not in theory, technically you can't actually do that unless you're already using the logo in commerce. So you actually have to be in business and using the logo as your source identifier to then say, hey, I want to stop other people from doing that. That way you can't just like claim that you own a bunch of logos and they make people come pay you for like that logo that you never use. So it's always good to do like a quick and dirty trademark search and hire a lawyer to do a trademark search to make sure that like you are not starting from something that already exists. And then you want to get that registered as soon as possible.
Okay, question here from Rob in chat. This is in regard to a lot of our students, and I can attest that I have seen this with my students as well. Many student development teams really want to commercialize. They want to take their projects and turn them into something, or take their student team and turn that into a studio, one way or the other. Does a founder agreement make sense in that case and help give them any kind of clarity on starting a business, like coming from a college team and moving beyond after they graduate?
I think it's just like a thought exercise. Yeah. I mean, coming together and coming up with a term sheet of what your agreement's going to look like when you have this business together. I don't think it's going to be a bad thing. You know, you might find out that you're actually a lot less aligned than you thought, or you're a lot more aligned than you expected. But again, just don't have nothing. Just pretend. Don't like assume like all these handshakes and good vibes are going to get you what you want at the end of the day, because they're just not. So something is better than nothing. Full on, corporate paperwork and all the operating agreements and the bylaws and all these other kind of good stuff that the corporate lawyers work on that I don't specifically touch are really important. But if, you just want to have a founder's agreement so that way down the road, you don't have to have these arguments over and over again, I think that's a good idea. I would let my co-panelist, probably she knows more, but.
Yeah, I don't have as much intellectual property knowledge as Zachary. So on the corporate side, I shared a link on the chat to the UPenn Entrepreneurship Legal Clinic that came up with founders agreements. They have a really handy dandy worksheet that what Zachary was talking about. It will actually help you align on values with your early co-founders, more than actually put an agreement together. I think that's what it's meant to do. But use it with caution, right? A lot of things change, especially commitment, right? When everyone is like initially on it, all in, and then 6 months later, it turns out, some person's putting 100%, the other people are putting 20%, and the initial agreement shifted. So a lot of negatives can also come out of a founder's agreement. For incorporations, typically, if you want to grow as a C Corp, and the C Corp is the tax entity designation that Evan can tell you more about, if you want to go the route of like becoming an Electronic Arts or a Niantic, and you want to be like a big gaming studio or have a big gaming company, you can start with a C Corp entity, like a corporation that has a C Corp tax classification. And if you want to do that, you can use Clerky, CLERKY. That's the most commonly used plain vanilla standard incorporation. Said they'll do it for a few $100s. But the biggest problem now is my entire formation business is cleaning up after Clerky. Because what you don't know about legal, you don't know. So when someone tells you this is a standard off-the-shelf form to use for your incorporation, you won't know if you are standard to be using off the shelf. A lot of things can be non-starred about you. Like one of your founders cannot be a US person. Well, you're no longer standard, right? One of you could, have a completely different tax situation than the second person, and then you're no longer standard. So lots of reasons why that might not be applicable to you, but thank you, Rob. I think he added a link to Clerky as well. But yeah, with the user beware. But now that all of these kind of AI stuff has started, too many people try to incorporate on their own. And then I guess Zachary and I kind of find them after they realize they messed up DIYing it. So
yeah. Speaking of realizing you messed up, you should have the founders agreement if you're going to do one actually signed. Don't just like print out like a handout and give it to all your friends and be like, this is our deal. Remember, if you want to hold somebody to it, you have to get them to sign it. It can be electronic signature, but
this one just came in, but it's related, so I'm going to jump to it. Asking about the founders agreement. Does this differ from an operating agreement? And if so, what are the primary differences between founders agreement and operating agreement?
Okay. I don't, Zachary, if you want to talk about an LLC, but an operating agreement is the main agreement that governs a limited liability company, which is not in tax classification, but it's a corporate classification. It's the basic form of a corporate entity status. A corporation is different from an LLC. An LLC is it's like a slug. They come in many different favors, forms based on states. Like you can make whatever you want out of an LLC. It's like a Lego entity type. You can have members, you can have managers, you can only have members. An LLC is basically used as the lowest form of a corporate protective shield, and because it's the simplest. And it comes with an operating agreement, and that's all you have at its simplest form. But if you want to be like a full-on corporation, then a corporation is different from a limited liability company. A corporation does not have an operating agreement. A corporation has a bunch of different things instead. It has a certificate of incorporation and it has bylaws, and the main stakeholders in a corporation are stockholders who own it, board of directors who have fiduciary duties to stockholders who supervise the running of the business, and then officers who then manage it on a day-to-day basis. And a stockholder, director, and officer can be the same people, but typically the plan for a corporation is they're all going to be different people as the company scales. Zachary, I'll let you kind of add in. But yeah.
If I could just quickly
Please,
say,
please.
if you're thinking about a C corp, you need to get a lot of help.
Yeah.
I've dealt with very few C corps in my entire career, but you know, they are there and they do have a purpose, but it's not something a bunch of guys sitting around trying to come up with do we go C corp or founders agreement? You know, that's not going to happen. Go ahead.
And I wouldn't even like necessarily put those in like the same conversation anyway. I would like say, are we going to do C corp or LLC or S corp or whatever separately from the conversation of like, do we want a founders agreement? Yes or no? It seems like the founders agreement you could think of as like the skeleton of what your company will be, right? But like maybe that never even comes to fruition. Whereas, you know, all these other documents that we are referring to here are like where you put like the meat on and actually like get into like the nitty gritty of like how things are going to operate and where the money's going to go and who has what rights. So I think the founders agreement is sort of just like a preliminary way to see if you're even close to being on the same page. Like if you're doing a talent agreement with somebody, you're going to have like a term sheet. Okay, I'm going to work this many days. I'm going to get paid this much. I'm going to show up for this thing. And it's like, if we're so far on the opposite ends of what we expect, like, you know, it's better to know that now than when we're passing a 20-page document back and forth. So that's how I sort of think about it.
Okay, want to get back to the group really quick. Yes.
You were talking about the tax credit. You said something like, if development takes, I think, a year, then it'll probably take a year and a half to get the tax credit. When is, in the eyes of the law, the development process done? Is it when you earn your first dollar? When you stop creating things to add to it? Like, you know, end of the cycle and you've done all your DLC and you're just like, done and not adding anything?
Yeah, real quick to repeat the question. For in regards to the tax credit and receiving it like after the game is done, what is considered done?
Well, let me just, before you get into
From the tax credit perspective.
as we mentioned before, they'll look at it at a video game as a multi-year process. So if you get a 4-year video game tax credit, at the end of each year, they're going to want to do an audit of what you spent that year, whether you're done the video game or whether you've introduced it, you're going to go to phase 2, phase 3, phase 4. So in that case, it's a period of time that determines, okay, now it's time to submit my expenses. Another one is if you're just getting a tax credit because you're going to develop a game like Qbert, and when the game is developed and sold or introduced and you're starting to make money, then that is kind of the end of it, and that's when you can apply for it. I don't know if that answered your question. Dave, you can add whatever.
Yeah, it depends. Like if it's a work for hire, right? You know, you got hired to produce this game. There's probably a beginning and end, then you give it to them. You know, that is the end right there. Mm-hmm. And it is when all the costs are incurred, when you've done and paid all of that.
And that is either a year or a completion of a particular project. A year in the case of a longer development.
So if you were to then come up with, like he was mentioning, DLC, downloadable content that someone can buy to use in their game, like several months down the road or a year down the road, does that change that timeline, or you still would say the actual video game was done at this date and now all these other like supplementary assets are?
You got to cut it off at some point.
Exactly, yeah,
Just
exactly.
going, you know,
So you wouldn't wait until like every piece of DLC you ever contemplated is released, is kind of what I'm understanding.
I've played games where I played the original version back in the early 2000s as a kid, and then they make an enhanced edition or whatever that like it's kind of a remake of the game, but it's like just the same game, it's all the same code, it's all the it's everything. If I did something like that hypothetically in 10 years for a game that I created today, would that like somehow fall under the same thing? It's all the same pieces of the same game?
you'd apply for and get another credit on
You know what
that.
I'm saying?
Yeah, you can't get a credit on those original costs if you already, you can't double up on the cost, right?
Yeah.
I have a question for the attorneys.
Oh, sure, please.
And maybe you touched on this earlier, but everybody in here, because I still get them, is going to get a non-disclosure agreement put in front of them and say, sign here. What do you tell people? If you're, even if you're just having a discussion, people give it to us when they say, I'm going to send you my cost. I want you to sign an NDA. It's like,
Right.
Okay, but you know what I mean? If you're working for somebody or you can say, we're going to talk about this idea, or if it's your idea, when do you give somebody an NDA? And I've seen most of them are pretty standard. So, maybe you could counsel them some on.
Yeah, definitely. I would say if you're receiving an NDA, the main thing you want to look out for is making sure there's not so an NDA, non-disclosure agreement, means we're going to have a discussion to evaluate whether we want to do business together. Everything I tell you is my confidential information. Everything you tell me is your confidential information. If either of us go and tell someone else any of our confidential information, we owe each other money, we sue each other, etc. The sneaky thing that I've seen sometimes is people will try to add language into an NDA. No one's going to share anyone's personal information, but by the way, everything that we talk about, I own, just so you know. And it's like, well, now there's like this question of, are you now actually like giving away what have you given away that's like intellectual property versus confidential information, right? And, if you are like an indie developer working with like a multi-billion-dollar company, you probably don't have the leverage to push back on that. But if it's more like an arm's length negotiation and you're just like with, someone else who's more of like a equal bargaining power counterparty, you just want to make sure that the terms basically say like, again, you keep my stuff confidential, I'll keep your stuff confidential. If we ever have to sue each other, it's going to be in this state. No one's going to ever owe more than this amount of money, etc. You really want to watch out for these like sneaky IP ownership.
Yeah. Also, if you have a great idea and you're just me, if you're just you, and it's like, and you go to a distributor or something, and they're like, oh, well, just online, tell us what your idea is. Don't do that.
Yeah, no.
Right. Because there's a chance you just gave it away.
You
right?
probably did. So I've written a lot of like the terms and conditions that like you guys probably don't even read. I don't even read like before you agree to. And a lot of them will basically say like anything you submit or upload to us, even if you still own it, we basically have like the worldwide royalty-free perpetual right to do whatever the hell we want with it without any notice or credit or like money to you. So you don't want to just like start offering stuff on someone's website if they send you a link.
Somebody puts an NDA in front of you, you don't have to sign it right there.
Yeah.
You can send it over to him, or send it to one of them. And
please.
Honestly, I don't want to knock down your billing on it.
No.
Probably in 15 minutes they can give you an answer on it. Like, oh, do this, or here's one you can give to them. Here's a standard one.
For everyone in this room, I would keep it as low cost as possible.
Yes, of course. Wait.
Yeah.
There's a lot of time that I spend on stuff I don't
watching-
even bill to because I just like want to help stuff. But go ahead.
Yeah. I don't want to take away from Zachary, but typically if someone puts an NDA in front of you, you first ask if it's standard business commercial. If it's standard business commercial, you should both be agreeing to an NDA form that's publicly used and vetted, instead of going with some custom version that you need to hire a lawyer to review or they need to hire a lawyer to review yours. For that one, I recommend onenda.org. It was put together by a bunch of tech Silicon Valley founders who wanted to make commercial transactions easier. But it does not apply to very important IP tech transactions. Like if you're doing an exclusive IP license of your entire game, or if you are doing like a big M&A type transaction, then a commercial off-the-shelf NDA license is not what you are looking for. For all of my sell-side M&A clients, we call it an NDA. I call it an NDA, but I actually make them sign, that counterparty sign a covenant where they promise that all the information they have received will solely be used for the purpose of evaluating the transaction. It's not actually a confidentiality agreement in that I'm going to keep your information confidential. It goes beyond that for them to promise that the only use is going to be to evaluate this transaction. And if I don't do that, then, what if the M&A falls through, right? They can keep your confidentiality, but within that potential buyer, they can now go out and target your customers that they learned about in diligence, right? So there are contexts where confidentiality is required, where you need an NDA, but to Zachary's point, a lot of NDAs are actually masquerading as something else, like IP assignment. So the best thing to do is try to use a standard form everyone knows and understands. And the second best thing to do is hire a lawyer if you must go with a custom form. And the third thing to do is absolutely hire a lawyer if, what you're trying to do is a very important type of transaction, and not rely on a commercial form of an NDA.
Very good. I'm actually, so now I'm going to ask a question that kind of like bounces off of something that you were kind of talking about in there about like having the idea and like, people say, hey, submit your idea before, and generally not to do that. A thing that I will see students do if they go to like a professional conference, like a game developers conference or something, is they'll want to talk to like a game designer or staff members, just like someone that they, either it's like their hero or it's just someone they meet at the conference and they're like, hey, I have this great idea and I want to tell you about it. The designer will be like, no, I don't want to hear it. Or they'll ask for a consultancy fee.
Yeah.
But the main thing that they typically say is that they're like, they don't want to be held legally liable.
Yeah.
Is that something that they should be concerned about? And like, what would you say to a student who, wants to like get advice from someone, but also again, like, wants to be mindful of their IP?
The person, so you're a student talking to like a designer and the student wants to tell the designer their idea and the designer says, don't tell me.
Feedback or.
Yeah, the reason why the designer says don't tell me is because they don't want years down the road you to be able to, you to go and say, hey, that's my idea, that's my intellectual property. I offered that to you at GDC and you told me you were going to pay me all this money. Don't you remember we had that conversation? They would rather just like keep themselves like totally clean of like your ideas and your feedback. The other thing is they might already be working on something that you think is your idea. They have it already like 80% done. And now if they were to hear that from you, they have to like decide whether to scrap it or take the risk that you're going to claim ownership of it. So they're not trying to be rude to you. They're just like everyone, like we talk about how important it is to protect your IP. That's all they're trying to do as well.
If you were to have them sign an NDA, but then tell them how to be protected with that.
You as the student, I mean, I don't know what the terms of the NDA say. Like if it's just keep each other's information confidential, I mean, you're I guess protected that like they're not going to go and run and tell a bunch of other people in the industry what you're doing, but they are not protected from you if you want to go after them and say, this was my idea, I told that to you at GDC and now you have to pay me.
Okay, so yeah, we have about 5 minutes total left, but I want to wrap this up really quickly. Oh, wait, I mean, point it over to Rob. Yeah, hi, Rob.
We're blocked by a pillar, so I can't get it.
Okay, sure.
I know we're close to ending, and I actually wanted to get the panelists all each should have something to say at the end. But really quickly, because I literally just had this happen, we have a lot of students go out on co-op Drexel's program, a lot of students who do internships, and I had a recent group come back and freak out because they were not only signing NDAs, which are common, but they were assignment of inventions.
Yep.
And the language is so comprehensive. If you fart in the middle of the night when you're our employee, we own that fart.
Yeah.
And they were really freaked about that. And to me, as a former employer in the industry, I thought of, hey, this is contractor work for hire. But this is more expansive of some of the potential.
It is more expansive because some works may not qualify as a work for hire. So that's why they're trying to say, and by the way, it's a work for hire, but if it's not, you assign it to me. And the other thing is, it is way overbroad. Like I've seen some of those for like game developers, and they're like, we own everything you make, including any like new biological organism or like chemicals. And I was like, I mean, are you going to make any of those? Like, do you want to own it? Like, if not, like, this is fine to sign. So it's one of those things where, again, they're just trying to protect their IP. It is overly broad. It's intended to be overly broad. It's intended so that you can never go and say, the thing that I worked on while I was under your supervision is mine. But it's not, like a deal breaker to sign something just because there's a lot of like unnecessary language in there, I would say. But it is scary, definitely, the first time you see it. Yeah.
And Robin mentioned wanting to do a closing question. For everybody, at the beginning we opened this asking about like for people just starting a business or just starting, what are like the common pitfalls? But people make mistakes even like when they're experienced or if they've been doing this for a little bit. So for small businesses and indie games, from each of your experience, when they are operating, what are some common traps or pitfalls that they make, like just in general day operations that you might like come across or have found in your experience?
I'm going to start with this really quickly.
Yeah.
And I see this across the board from a tax perspective is they just don't put anything aside for taxes, right? And they think every dollar they make, they can go and spend it the second they get it. And then they get sticker shock next year. And not only is that stressful, but it comes with usually penalties and you're paying more than you need to. And that's honestly what sucks the worst, because I want my clients to have every dollar they can so they can, be sustainable and keep reinvesting in their studios and their businesses and just keep on going.
I'm actually going to shift gears a little bit and say not considering privacy law is going to be a really big issue. A lot of people don't want to have a privacy policy or think about complying with the patchwork of laws of all the 50 states when it comes to like collecting the information of your users. But this is something that regulators are paying more and more attention to, especially for users or children. So I would say you always want to be mindful about your data collection and use processes. And especially if you're going to put something on the market, don't do that without talking to a privacy lawyer.
I would just say, know what you know and what you don't know and get help, ask questions. I mean, I've worked with some of the most brilliant people who do things on a computer that just blow your mind, but they can't manage to fill out a little timesheet and submit it for something. And, if you're, you need somebody as your business grows who understands the accounting, who understands how to make sure you're not getting ripped off, who understands you need to fill out a sales tax form online every quarter, even if it's zero. I mean, you just got to try to keep, have people around or get advice that helps you with the stuff you don't understand yourself, and just don't assume it's going to get done.
When you have an idea and you start producing something, money's going to have to come from somewhere, right? And if there's a small group of you or a big group, if you have a rich uncle or a parent who's going to put in $50,000 or $100,000, it's probably going to be in the operating agreement. What happens to that? Are they going to get the first $100,000 out, or do they own half of everything from forever? So make sure you're going to be really happy to get that $50,000 or $100,000, but it can be an obstacle, right? So are they getting that back if first money's in, or are they going to own how is that going to work?
I'm just probably is the very last because we're at the last minute. So I'm going to just summarize and say I agree with everything And in my experience, the founders who last from formation to exit don't take themselves too seriously. They take their work very seriously, they take their development very seriously, but they don't take business personally. It's a very, very important distinction. Because when you're in gaming, you're going into investment, you're seeking investors, you're doing M&A, there's going to be a lot of rejection and a lot of noise, some positive and negative, giving you feedback. It's very important that you know your own worth as an individual and you don't tie it all to your work. Because part of what will make you go from a founder to someone who scales a growing company and manages 20 people to someone who does an IPO or an exit is recognizing what you're good at. And it's actually going to be very few things. So for all the other things that you know you are not an expert in, like accounting and tax and legal, hire the right people when you can afford it, right? And listen to those experts, and they will help you kind of grow in your role. So just have fun, but don't take it too personally on yourself. A rejection of your business is not a rejection of you.
Thank you so much to our panelists. This has been amazing. Absolutely. Thank you so much. A lot of the resources, a lot of things are already posted to our Discord for people who need to grab them. Thank you all so much for attending. Thank you to everybody online, so other people, including Saida, can see all the wonderful people here in person.
Yes.
Really, really appreciate all of you. IGDA will be back in May for something. We'll tell you more about that on our Discord. One more time, thank you all so much, guys.
Thank you for having us.
Thank you.
So we're gonna close down the Zoom and jump.